Line?
Yes, sir.
All right. If by chance you should need to speak with him about anything, since you're not seated here in the courtroom next to him, just tell me. I could put the two of you into a breakout room. It'll be just the two of you on the screen, and no one else will be able to see you or hear you on the computer, and the deputy would step out of the room while that's happening. Okay?
Yes, sir.
All right. Now, Mr. Bowline is charged in an 8-count indictment. Looks like 4 counts of aggravated trafficking of methamphetamine and 3 counts of aggravated possession of methamphetamine and 1 count of theft by deception. And the matter, I believe, is set for a trial. I'll find the date here. On January 22nd. Now, Mr. Bowline, I've been presented with a plea of guilty form, which indicates you're going to change your plea on counts 3 and 5 to guilty. I'm going to first hold up the first page of that has your case number and name and plea of guilty and then the 2 counts there. Do you recognize that?
Yes, Your Honor.
Okay. This agreement's 4 pages long. At the top of the page 1, there's a sentence that reads, "I enter this plea voluntarily." And immediately below that, there's a line for signature defendant. And I'm going to hold that up to the camera and ask you if that is your signature there on that document.
Yes, Your Honor.
When did you sign this plea form, Mr. Bowline?
A little over an hour ago.
All right. Mr. Wagner was with you then when you signed it?
Yes, Your Honor.
And did he explain everything to you and answer any questions you had before you signed it?
He did.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
And did you sign this agreement then voluntarily?
Yes, sir.
And you still want to go forward with this plea now?
Yes, sir.
All right. The document says on page 1 you're going to plead guilty to counts 3 and 5. Both of those are aggravated trafficking of methamphetamine under 2925.03A1. Both are second-degree felonies. Further states you understand that the maximum penalty on count 3, it's the same for both. They're both second-degree felonies, so the penalty is 2 years as a minimum up to 8 years as a minimum set by the judge. I can pick any number in between from 2 to 8. And a fine of $15,000 is available on each count. There's a mandatory fine of $7,500 in each count. Possible license suspension of 6 months to 5 years. And in this case, any prison term that's ordered by the judge is mandatory. It must be served. There can be no early release or no probation or community control. Do you understand that?
Yes, sir.
All right. Now, under the law, offenses of this nature that are considered that are classified as second-degree felonies, as I said, the sentence that would be imposed by the court if you plead guilty would be anywhere from 2 to 8 years. And that would be the mandatory sentence you would have to serve. Now, it is possible that the sentence could be extended by 50% as to one of those charges. The law only permits, they could both be subject to being extended, but in each case, if there's more than one to be extended, only one is extended. And so that means that you could receive, if you received a sentence of 2 years on each charge, one of those sentences could be extended to 3, because 1 is half of 2. If you received a sentence of 8 years on either charge, then that sentence could be extended up to 12. Again, that would be by the Department of Rehabilitation Corrections at their discretion. Now, these sentences, if you plead guilty or are found guilty, could be ordered to be served consecutively. And so the worst case scenario is if I were to impose a sentence of 8 years on each count, that would be 16 years total if they were ordered runs consecutively. And then, as I indicated earlier, the DRC could extend that by up to 50% on 1 count. So that means that your potential maximum sentence in this case could be 16 years as a minimum and a total maximum of 20 years because 4 years can be added on one of those charges. The minimum would be 2 years up to 3 years as a maximum with 1 was added if they were to be ordered to serve concurrently. Do you understand that?
Yes, sir.
Okay. Now, are you facing any other felony charges at this time?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
All right, now, under the law, as I indicated to you, there's no possibility of community control probation. You must be sentenced to prison and serve the minimum term imposed by the judge. Now, upon completion of that term, or any additional term that DRC may extend on one of those two charges, up to 20 years, or 1/2 of whatever sentence I impose. Upon that completion of that sentence, then it is mandatory that you be under post-release control supervision under conditions set by the Adult Parole Authority for a period of at least 18 months up to a maximum of 3 years. So you would be supervised by a parole officer on the terms that the APA sets. And if they determine that you have not complied, they could return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you committed a new felony while under post-release control, then in addition, whatever sentence could be imposed by the judge in that case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time was left on that period of post-release control, whichever is greater, and if that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
All right. Now, the charge in, do you, no, I need to read the charges first. All right, so count 3 is, alleges that on or about November 18, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount and less than 50 times bulk amount. And count 5 alleges that you did the same thing on the next day, November 19, 2022, but otherwise the charges are identical with the same penalty that I've just described for you. Now, do you understand what it is you've been charged with in each count, what the state said you did, when, where, and how they let you did it?
Yes, Your Honor.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues of the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
And are you satisfied with his advice and competence in this matter?
I am.
Excuse me. Now, has anyone threatened you in any way to make you plead guilty here today?
No, sir.
And are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Right now, on page 2 of the agreement, there are several sentences that are printed in bold and underlined, and they contain what I call the substantive portion of the plea. That is the plea agreement. It says, defendant will enter a plea of guilty to count 3 and count 5. State will dismiss remaining counts. State and defense jointly recommend 3 years mandatory incarceration on count 3, consecutive to 2 years mandatory incarceration on count 5, to be served consecutively to the term of incarceration defendant is currently serving. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force in the amount of $2,200. Do you understand all that?
Yes, sir.
Now, has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the judge is not bound by the agreement of the parties. And so even though there's an agreement that you should receive a total sentence of 5 years, the judge is not bound by that. So if you plead guilty, I'm not required to follow that agreement. I could give you as much as 16 years, which could mean a total of 20 years if DRC extends one count by 4 years. And I could suspend your license for 6 months to 5 years and impose the maximum fine on each count. You understand that?
I do.
And now you're serving a criminal sentence out of, is it Clinton County currently?
Yes,
and
sir.
Warren County?
Just Clinton County. Warren County dropped.
Okay.
Yeah.
All right. Well, if you plead guilty to the charges here, these sentences could be served consecutively to the sentence that you're currently serving. So that would extend your out date. Do you understand that?
I do, sir.
Okay. Now, do you hold any license or certification from any state governmental agency that regulates any occupation, trade, or profession?
No, sir.
And you have constitutional rights, you must understand, before I can accept a plea. First, you have a right to have counsel, and I appointed Mr. Wagner to represent you. That wasn't simply to work the case out. but to provide any defense that could be available to you under the law that you'd like him to provide. So if you decide you do not want to do this, he'll continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then that jury of 12 would decide, after being instructed by the judge on the law, as to whether the state proved your guilt, and that verdict would have to be unanimous in each case, in each count. In other words, all 12 of the jurors would have to agree as to each count. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you could waive, which means give up in writing your right to have a jury trial. And in that case, you could have what's called a court or bench trial, meaning that the judge would be the one who would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, in the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court and testify in public in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney would ask questions. That's cross-examination. And the purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution and the law, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. You understand that?
Yes, sir.
Right now, under the Constitution, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right. Now, under the Constitution, you're presumed innocent of these charges till proven guilty by the state on every essential element of each offense. What that means is the burden of proof isn't on you to try to prove you're not guilty because you've been indicted. In fact, under the law, you don't have to present any evidence to defend yourself at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt, but proof beyond a reasonable doubt on each count, which is the highest burden of proof that is known under the law. You understand that?
Yes, sir.
Now, originally, you entered a plea of not guilty. That plea denied the allegation, and each count of the indictment denied you committed any crime and exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that there are crime, that you committed that crime. And that plea waives or gives up all the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront the witnesses against you and cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, same as the state. It would waive or give up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. It will waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, which is what's likely since it's a mandatory prison term. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence under the certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Bowline?
I am.
Now, do you have any questions about the charge and the possible penalties?
No, Your Honor.
You understand it?
I do.
Have any questions about the plea of guilty?
No,
You understand it?
I do.
Do you have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
I do.
Have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
Now, is there anything you need to speak with Mr. Wagner about before we go any further?
No, Your Honor.
Do you have any questions about anything that we've talked about here today?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea, plead guilty to counts 3 and 5 pursuant to the terms of the plea agreement that we've just gone over?
Yes, Your Honor.
Then as to count 3, which alleges that on or about November 18, 2022, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount or less than 50 times bulk amount in violation of Section 2925.03A1, a second-degree felony carrying a mandatory prison term of between 2 and 8 years set by the judge, and a maximum term of up to 12 years if determined by the DRC that should occur. A fine of $15,000, a mandatory fine of $7,500, and a possible life suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 5, which alleges the same language other than it's alleged to have occurred on November 19, 2022, but it's otherwise the same language, the same penalty, same crime, how do you plead?
Guilty.
All right, the court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Pleas accepted in order to file defense found guilty of counts 3 and 5. Remaining counts are dismissed. And defendants found guilty of 3 and 5 as charged. All right, now the court will not order pre-sentence investigations since these are mandatory sentences, and so I'll go ahead and proceed with sentencing forthwith. Anything from the state? Dan?
Your Honor, we would just ask the court to follow the joint recommendation. Would note the restitution is actually $2,220, not $2,200.
Oh, okay.
And
2020, not 2,200.
yeah, $2,220.
All right, I'll correct that on the form then. All right. Go ahead.
And we do appreciate the efficient nature in which the case was handled. Mr. Bowline came in very quickly, took full responsibility for his actions. I have to say I was disappointed when Investigator Sanders brought me this case because I'd seen Bryce out and he was doing so well. So the fact that he went down this path again was very disappointing. That being said, he takes full responsibility. We do appreciate the efficient way that he worked the case out. And we just ask the court to follow the 5-year recommendation.
All right, Mr. Bowline, anything you'd like to say?
No, Your Honor.
All right, it is a judgment order of the court that you be and are hereby sentenced to a term on count 3 of 3 years to the Correctional Reception Center in Oran, Ohio. As to count 5, you are sentenced to a term of 2 years of incarceration. Each of those sentences are to be served consecutively to one another for a total of 5 years. And those are mandatory terms that must be served. There can be no early release. Now, it is also possible that the Adult Parole Authority would extend the sentence on count 3, since it's the longest sentence, up to 1/2, which would be another 1.5 years. So that means your total sentence is at least 5 years mandatory, and could be as much as 6.5 years. You're also ordered to pay the court costs when judgment, grant, and execution is ordered, and I believe you were served with your indictment while you were in prison. Is that correct?
Yes, sir.
All right, so there's no jail time credit on this charge. Now, upon completion of the prison term, it is mandatory you be placed under post-release controlled supervision for a period of at least 18 months up to a maximum of 3 years by the Adult Parole Authority. You'll be supervised by a parole officer on the terms they set. If during that period of time they determine that you have not complied, they can return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum of 5 years prison term for all violations. However, if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively, the sentence of the new case. You're also ordered to pay the court cost, which judgment is granted and execution is ordered. If you do not do that, then the court could order, the clerk of courts could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your sentence, not while you're in prison, but once you complete it, the court could permit you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you worked, reduce your judgment by that amount until paid full. It's also ordered you make restitution in the amount of $2,020 to the Highland County Task Force
$2,220, 2220.
Oh, $2220, okay, $2,220 to the
Yes.
Highland County Task Force, and that money be paid through the victim witness escrow, restitution escrow account, and you pay any fees associated with that. There'll be no license suspension. Now, the court will also find that due to your incarceration and the long period of incarceration you'll be facing on this charge, there's no likelihood that you're going to be able to pay the fee, the mandatory fine, since the court did appoint counsel for you, found you indigent, so the court will waive the mandatory fine. All right, is there anything further from counsel?
No, Your
No,
Honor.
Your Honor.
All right, to remand it back to custody then, Mr. Bowline, thank you. Would you bring in Derek Lane, please?
Yes.
And after Mr. Lane, we'll do Matthew Jackson.
Okay. Great. You can have Jackson have a seat out here.
All right, just case number 23, CR 202, State of Ohio versus Derek A. Lane. Are you Derek A. Lane appearing there from the jail?
Yes, sir.
All right, this is a bond review hearing. Mr. Lane was arraigned last Friday, and this hearing is being conducted pursuant to statute. Appearing on behalf of the defendant is his attorney, Dennis Kirk, appearing from his office by Zoom, appearing from the prosecutor's office, Prosecutor Collins. The defendant was indicted on the 5th of December for grand theft of a motor vehicle, receiving stolen property, 4-3 felonies, and forgery, 5th-degree felony. And the court set the bond in the amount of $5,000. All right, Mr. Kirk, anything you'd like to say regarding the bond?
Thank you, Your Honor. I just was appointed, I believe, yesterday. I've not, never represented him before and was not on the prelim, so I don't know a whole lot about the matter yet. So I understand he's not been able to make bond so far. Just asked the court to review the bond further, and then if we find out additional information, we'll certainly file a motion.
Ms. Collins, on behalf of the state.
Your Honor, the allegations that Mr. Lane are charged with both involve victims, separate victims. Additionally, his bond, I believe, is only $5,000, which is not egregious based on the nature of the offenses. And finally, but definitely not least of which, his prior criminal history is substantial.
I did neglect to ask, did you notify the victims of the time, place, and purpose of this hearing?
Yes, Your Honor, they are aware.
All right, thank you. All right, well, looking at the record here that I have from the Ohio Court Network, I see previous convictions for illegal assembly and illegal manufacture of drugs, having a weapon under disability, and assault, and criminal damaging, and also felonious assault. So based on that, and in order to make sure the defendant does appear, the court feels that the $5,000 is the appropriate bond, so the bond will remain the same. All right. Let's see, who's the other bond review we have?
We have Mr. Jackson.
All right, Matthew Jackson will be next, please. And after that, Allan Shoemaker.
Okay.
Let's see, what's Jackson's case number?
216, Your Honor, 213, 216, 23, 216.
216.
Correct. Yes.
Do you see this?
All right, are you Matthew Jackson appearing there from the jail?
Yes, Your Honor.
All right, this is case number 23 CR 216, State of Ohio versus Matthew Jackson. Mr. Jackson is appearing for a bond review by Zoom. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. Defendant was arraigned last Friday, I believe, for having a weapon under disability and grand theft of a firearm, both third-degree felonies. Bond was set in the absence of counsel, and therefore, pursuant to statute, the review hearing is being conducted. All right, Mr. Armentrout.
Your Honor, I was actually just appointed to this case yesterday. I did speak with Matthew by phone this morning. He doesn't have the ability to make any kind of bond, Your Honor. If something changes, I'll file a motion.
All right. Well, the court will note that this offense was allegedly committed just a couple of weeks after he was put on community control for the previous charge of having a weapon under disability. So bond will remain the same. All right. Thank you.
I think this is the first pretrial also.
Yes.
Oh, is it? Okay, thank you. Oh, yeah, okay. So have you haven't had a chance to file any discovery or anything yet?
No, Your Honor.
Okay, all right. Well, we'll just discuss that then at the next time.
Okay.
All right, thank you. All right, Allan Shoemaker will be next. Yeah, because I think Miss Witt's on. Yeah, Miss Witt's on, so. What is Huffer's number?
Shoemaker?
No, no, Huffer, I got Shoemaker. Huffer, Jason Huffer.
Huffer is 160.
160?
160.
Okay,
Should be
yep, it's down here. I got it. Yeah.
two-thirds of the way down.
Yep. All right, this is case number 23 CR 207, State of Ohio versus Allan Shoemaker. Are you Allan Shoemaker appearing there from the jail?
Yep.
All right. Mr. Shoemaker is represented by, I believe, Mr. Kirk and Ms. Witt. And the state is represented by Prosecuting Attorney Collins. Defendant is charged with violating a protection order or consent agreement. And the matter is set for trial on January the 8th, so this is the final pretrial. Now, is discovery complete on both sides?
It is from the state, Your Honor.
Okay, Ms. Witt, I know you were in this case first, and Mr. Kirk's been added as co-counsel. Is the discovery complete from the defense point?
Yes, we have not submitted the compliance yet, but we met with Mr. Shoemaker yesterday and don't believe that there's any additional discovery, so I'll submit that.
All right, thank you. And there's no pretrial motion?
No, none that I'm aware of.
Okay. And have any has a written plea offer been provided?
Yes, Your Honor.
Okay. And is the defendant going to reject that in writing, Ms. Witt or Mr. Kirk?
I believe so, Your Honor.
All right, if you would then go ahead and accomplish that. And then we'll just go ahead and presume that this matter is going to go to trial then on the 8th. Now, I believe we did set both cases together. So is there any objection? Is there an objection that these cases being tried together, since it's I believe it is the same alleged victim, isn't it, Mrs. Collins?
I think the other case was dismissed, Judge.
Oh, that's right, it was. I forgot. Yeah, so it's just this case. That's right. And by the way, was the alleged victim of this offense notified of the time, place, and purpose of this hearing?
Yes, and she does not wish to be present for the hearing.
All right, thank you. Okay, so we'll go ahead and just leave this on the trial docket. If by chance there should be any development, council will let us know. We'll make sure that it gets on the docket. Okay, Jason Huffer will be next then from the jail. And then after that, we'll do Mr. All right, case number 23 CR 160, State of Ohio versus Jason Lee Huffer. Are you Jason Lee Huffer appearing there from the jail?
Yes, sir.
All right, this is a pre-trial being conducted by Zoom. Mr. Huffer's attorney is Danielle Witt. And
Is she present?
she is present down there on the screen, yes. And then representing the state is Prosecuting Attorney Collins. The defendant is charged with possession of heroin, a felony of the 5th degree, is set for trial January the 8th. And I note that he's in custody, but I believe he's on an OR bond in this case, is he not?
Probably not, Judge.
Oh, no, he originally was, but then he failed to appear, and I had him...
It said at the jurisdiction though on my paperwork.
Okay, hold on a minute. Yeah, he was just taken into custody November the 17th, and so he's being held currently on
I've never seen an affidavit.
You be quiet. Don't interrupt me again. I'm looking at the file. I don't show that we had a hearing after he was arrested. On this capias. Is he being held on any other charges currently?
I was compliant to probation.
Ms. Witt, do you know if he has any other cases?
None that I'm aware of, Your Honor.
All right, okay. All right. Well, then, in order to get that on there, I'll put on an entry that the defendant is, bond will be $2,500 plus OR, $171 deposit prior to release. And if you do make that bond, Mr. Huffer, you're to report to probation. And immediately upon release, and then comply with the pretrial supervision orders and bond from your arraignment entry. All right, now, is discovery complete in this case from both parties?
It is from the state, Your Honor.
Ms. Witt?
Your Honor, actually this morning I did file a motion for, to evaluate Mr. Huffer's competency. I'm not sure if it's in the court's file yet.
No, it's not. These cases were pulled yesterday. So you filed a motion for competency evaluation?
I did.
All
I
right.
have a note here, Your Honor, that shows that I'm totally competent to stand trial, which is a question. I've already went through it, already completed it through Twin Valley. They said I was competent to stand trial, which on my when I said I wanted to go to trial for all my misdemeanors, they put me on valuations. I was told by the people where I was not at that they will show up for court and I will win.
Okay, well, Mr. Huffer,
But they were just misdemeanors.
do you have any hearing problems, Mr. Huffer? Do you have any problem hearing me?
They dug my
Can you
ears
hear
out.
me, Mr. Huffer?
Yeah.
All right. Well, did you recall, or maybe it's your memory, but I told you to be quiet, okay?
Yeah.
So quit talking.
All right.
Don't talk. Now, I don't know what happened in any other case, but under the law, I have to have an evaluation in this case. Doesn't matter what happened in the other cases, the result most likely be the same, but it may not be. But whatever it is, it is. So the court is going to order that you be evaluated, and we'll set that matter. We're going to have to continue the trial. And so today is the 13th. So we usually give them 30 days to get that done.
Thank you.
So that means January 13th would be the earliest. And let's see, I don't have next year's calendar out yet. But I believe the 13th is on maybe on a Saturday this year, because it looks like
It is.
so we will set the matter for hearing on January the 18th. The defendant will be held without bond until the examiner has the opportunity to meet with him, given his previous non-appearance. And then once the examiner is there, then if you have the ability to make the bond, Mr. Huffer, you may post the bond of $2,500 plus the $171 deposit, and then report to probation. But since there's already been a case issued for you once, I'm going to make sure you stay there until they can get to you. They may be able to get to you in the next week or 10 days. I don't know. We'll just have to wait and see. All right. Now, is there anything further in council?
I'm like.
I'm not talking to you, Mr. Huffer. Now, you be
I do have
quiet.
rights.
Mr. Huffer, be quiet. I wasn't talking to you. When I say counsel, I mean attorney. So I asked if either attorney had anything to say. I didn't ask if you had anything to say, because you're not to be speaking unless I ask you to speak. Now, do either of the attorneys have anything that they would like to say?
Not from the state, Your Honor.
All right.
What time was that hearing on the 18th?
I didn't say. Thank you for pointing that out. 1 o'clock.
Okay, thanks.
All right. That's it from the jail? All right. Okay. I believe that's all we have for you, Deputy. Thank you.
Yep, thank you.
All right. Bridget Brooks. All right, case number 23 CR 195, State of Ohio versus Bridget M. Brooks. Are you Bridget M. Brooks appearing there from the probation department?
Yes, sir.
All right. This is a hearing being conducted by Zoom. Ms. Brooks is appearing from the probation department. Her attorney is Jeffrey Blosser, who is appearing from his office, or on Zoom at least. Appearing on behalf of the prosecutors is Prosecuting Attorney Collins. As I indicated, this is a pre-trial. Ms. Brooks was indicted along with, looks like 1, 2, 3, 4, 5, 6 other individuals in a multi-count indictment. Her trial is set for January the 8th. Looks like she was indicted on counts 25 and 26. All right. Now, I have received a plea of guilty form, Ms. Brooks, which indicates that you're going to plead guilty to an amended charge in count 26 of possession of hashish liquid, a third-degree felony under 2925.11. Now, I'm going to hold first of all, Mr. Blosser, do you and your client both agree this matter can be conducted by Zoom rather than an in-person appearance before the court?
Yes, sir.
And you're all right with that, Ms. Brooks?
Yes, sir.
All right, since you and Mr. Blosser are not seated together in the courtroom, if at any time you need to talk with him, I can put you and him into a breakout room where just the two of you will be on the screen talking, and no one else that's there on the screen now will be able to see you or hear you, okay?
Okay.
All right. Now, so the first page on this has your case name, number. It says plea of guilty, amended count 26. I'm going to hold that up to the camera and ask if you recognize that form.
Yes, sir.
And on page 3, about halfway down the page, there's a sentence that reads, I enter this plea voluntarily. Below that appears the signature of defendant line, and it looks like BR. Is that your signature there that I'm holding up to the camera on that page?
Yes, sir.
All right. Now, when did you sign this, Ms. Brooks?
About a week ago, maybe-ish.
All right, and when you signed it, did you understand it was agreement to plead guilty, which means there's not going to be a trial? The next step in your case would be a sentencing hearing?
Yes.
And did you go over this with Mr. Brooks or Mr. Blosser before you signed it? And
I did.
have him explain everything to you and answer any questions?
Yes.
Do you feel that you had enough time to fully consider the matter before signing this agreement?
Yes.
Did you sign the agreement voluntarily?
Yes.
And is it still your decision to go forward with this plea voluntarily today?
Yes, sir.
All right, now, currently you're charged in count 26 with possession of hashish, which is a second-degree felony that carries a possible prison term between 2 and 8 years as a minimum, up to an additional 1/2 as a maximum. So it could be anywhere from 2 to 3.5, or from 8 to 12 years as a potential range of sentences. There's also a possible fine of $10,000, or on that charge, a fine of $15,000. Now, this plea of guilty form is saying on page 1 that you're going to plead guilty to a third-degree felony, and so I believe Ms. Collins is that accomplished by reducing the allegation of the amount of hashish.
Yes, Your Honor.
And what would be the range? It would be less than 400 grams, but what would be the next range down?
I believe it's 200. Just 1 second.
Huh? Oh, in the bold part? Okay, let me look here. Yes, it says 50 to 200. Okay. All right, thank you. All right, so what that means is the indictment currently charges you with a second-degree felony, and by reducing this down to, okay, well, I have a question now. That makes me wonder. If it's over 400 grams, is that that is apparently the minimum for a second-degree felony. That means if you're between 50 and 200 as a third-degree felony, what is 200 to 400?
It doesn't change.
It's the same?
Mm-hmm.
Okay. Well, I haven't had
So
these
what
types
changes?
of cases.
What changes is whether or not it's mandatory prison for an F3 or presumption and stuff like that.
All right. So
But the level doesn't change.
So at this amount, it is a low-tier third-degree felony.
At the new amount,
Yeah, with the amended amount to 250 to 200, it makes it an eligible low-tier felony
yes,
of the third degree. All right.
yes.
You agree with that, Mr. Blosser? Uh-oh. Mr. Blosser? I believe he is froze up.
Froze.
Yeah, there is no response there. He's not. He's frozen up. I'm going to have it call him. All right,
I'm
he just-
texting him.
Okay, thank you. He just went off, so I'm guessing he's figured it out. I was going to have you call him. Mr. Blosser froze up, but he signed off, and Ms. Collins is texting him.
Your Honor, may I inquire?
Yes.
Ask one question?
Yeah.
I got one of my guys sitting out the probation department.
Where's Mr. King? Stepped out.
I think he just went around the corner and talked.
I was gonna say, if we can grab him, we can do your case here real quick.
Yeah. I think he was-
Is yours a first or final?
It's a first.
All right, let's get
Yeah.
him in here and get him knocked out real quick. What case is
Judge
yours?
said, I'm sorry,
Faulkner.
Jeff says he's trying to get in.
Well, he's not showing that he's applied yet. I'm gonna go ahead and do a quick first pretrial here while we're waiting on him. What is the case again?
Faulkner.
Faulkner?
Okay, Benson Brooks.
John? Miss Collins, you might want to text him and tell him to shut off his device and restart it because
Okay.
I don't see him, there's nothing showing that he's in the waiting room.
On the record, Faler, Your Honor.
All right, case number 23 CR 203, State of Ohio versus John L. Faulkner III. Present for the state is Assistant Prosecuting Attorney King. Present for the defendant's attorney Bruce Wallace. And are you John L. Faulkner III?
Yes, sir.
All right, Mr. Faulkner is charged with breaking and entering and theft from a person of
Did
protected
Mr. King
class.
come back in?
Mr. King, has the alleged victim or victims of these offenses been notified of the time, place, and purpose of this hearing and the right to be heard?
Yes, Your Honor, the state has been in communication with the alleged victim. He's elected not to appear today.
All right. This is a first pretrial, and final pretrial is set for January 17, and trial is set for February 12, I believe. If I could read my writing. Well, I can read the bailiff, so it's February 12. Now, I see that the state provided discovery and also served a bill of particulars. You received those, Mr. Wallace?
I did, Your Honor, and I've also received today a written plea offer from
All
the
right.
state.
All right, and you don't anticipate any pretrial motions?
I do not. I anticipate this will likely be a plea.
All right. All right, well, if it's not resolved by the pretrial, your discovery will be due by the final pretrials and any pretrial motions that might arise too. And your client is aware of the written plea offer?
Yes, he is. I just gave it to him here today.
All right, anything else we need to discuss then?
No, Your Honor.
No, Your Honor.
All right, we'll see you back on the 17th. If you should resolve the case and want to, we'll get it on the docket more earlier, then just let us know.
Okay, thank you.
Thank you. I still don't see Mr. Blosser. I'm going to do one more case here, and then if he's not able to sign in, we'll go in with the other people that are on the screen. All right, this is case number 23 CR 134, State of Ohio versus Joshua Queen. Present for the state's Assistant Prosecuting Attorney King. Present for the defendants, Danielle Witt. And are you Joshua Queen?
Yes, sir.
All right, Mr. Queen is charged with one count of aggravated possession of methamphetamine, a fifth-degree felony. Mr. Queen had previously filed a motion for intervention in lieu, which the court denied because of his ongoing drug usage, and the matter was set for trial. I have now been presented, Mr. Queen, with a plea of guilty form, which indicates you're going to withdraw your not guilty plea and plead guilty to the charge. The charge is aggravated possession of methamphetamine, a fifth-degree felony, under 2925.11 of the Ohio Revised Code. On page 3 of this document, there's a sentence that reads, I enter this plea voluntarily, and a signature, Joshua W. Queen. Is that your signature I'm looking at here?
Yes, sir.
When did you sign this document?
Today.
And when you signed it, did you understand it was agreement to plead guilty, which means there's not going to be a trial? And the next step in your case would be a sentencing hearing.
Yes, sir.
Keep your voice up, please, if you would. Now, did you have enough time to go over this matter before you signed it?
Yes, sir.
Feel that you were rushed or pressured in any way?
No.
Did your attorney explain everything to you before you signed it?
Yes, sir.
Did you understand it was an agreement to plead guilty, meaning there won't be a trial and the next step would be a sentencing hearing?
Yes, sir.
All right, now, this possible sentence for this offense, if you are convicted, is 6 to 12 months incarceration, a fine of up to $2,500, and possible life suspension 6 months to 5 years. You understand that?
Yes, sir.
Now, are you on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No.
And now, if you are convicted of this offense, you're subject to be incarcerated for up to 12 months. If that incarceration should ever be in a prison, you, upon release, would be subject to post-release control, meaning that you'd be supervised by a parole officer in the terms they set by the APA sets for up to 2 years. And if during that period you violated those conditions, they could return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half your prison term for all violations. But if you commit a new felony, under post-release control, then in addition, whatever sentence the judge in the new case can impose upon you, that judge could also sentence you to an additional term of a year or whatever time is left on that period, whichever is greater, which would have to be served consecutively sentenced in a new case. Do you understand that?
Yes, sir.
Now, I could, instead of sentencing you to prison, put you under community control, which means you'll be supervised by a probation officer in the term set by the court for up to 5 years. If during that period of time it was alleged that you had not complied, the probation department would file a notice of that in writing. There would be a hearing. Be entitled to have an attorney. If the outcome of that hearing was that you'd failed to comply, at that time the court could revoke your community control and then sentence you to prison for between 6 to 12 months, fine you $2,500. And if you should be convicted of another felony while under post-release control, any sentence could be, in a new case, could be imposed, be served consecutively to this case. Do you understand that?
Yes, sir.
Now, the charge in this case alleges that on or about November 26, 2022 in this county, he did knowingly obtain, possess, or use Schedule II controlled substance with methamphetamine. And that's the charge with the penalty I just described. You understand what it is you're accused of having done, when, where, and how the state alleges you did it?
Yes, sir.
And have you had the opportunity to discuss the nature of the charge, the evidence in the case, possible legal issues in the case, and possible defense you might try to raise at trial with your attorney?
What is it?
Have you talked about the case with your attorney?
Yes, sir.
Are you satisfied with their advice and competence in this matter?
Yes, sir.
Are you are you under the influence of drugs or alcohol at this time?
Nope.
You sure?
Yep.
When's the last time you used? I think I
2
just
weeks
got a
ago.
report. Huh?
2 weeks ago.
Okay. All right. Has anyone threatened you to make you plead guilty here today?
Nope.
Now, the agreement states on page 2 that you're going to enter a plea of guilty to count to the indictment, and then the state and defense are going to jointly recommend community control and substance abuse treatment. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
Yeah. Well, is it?
Has anyone promised you anything other than that to get you to plead guilty?
No.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
You have certain rights you need to understand before you can accept your plea. First, you have a right to have an attorney, and I appointed Ms. Witt to represent you. That wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you'd like her to provide. So if you decide you don't want to do this, that you want to defend against the charge, she'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence will be presented, and then that jury would be instructed on the law, and they would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Excuse me. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Yes, sir.
Right now, under the Constitution, you have the right to confront the witnesses against you and to cross-examine them through your attorney in open court. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Yes, sir.
Now, I'm not talking to you, Mr. Krager. I'm talking to the individual in court.
I'm sorry.
Okay.
I apologize.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily at your request, court issues a court order that's called a subpoena, and that forces those people to come into court to testify if you want them to, even though they don't need to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means that no one can make you testify at any time in this case. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one can even talk about it except in one situation, and that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right, now under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
All right. Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they constitute a crime, that you committed that crime. And that plea waives, gives up all the rights that I've described for you this morning, or this afternoon, except one, your right to have an attorney. Well, you have a right to have an attorney no matter what your plea. With that exception, your plea of guilty would waive or give up your right to a jury trial, would waive or give up your right to confront witnesses against you and cross-examine through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on you, the same as the state. Waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge and possible penalty?
No, sir.
You understand it?
Yes, sir.
You have any question about the plea agreement?
No, sir.
And actually, I think I forgot to read that to you. But the agreement is that you will enter a plea of guilty to the indictment, and they will recommend you get community-controlled substance abuse. That's your understanding?
Yes, sir.
Okay. Now, do you have any questions then about the constitutional rights I've explained?
No, sir.
Understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, sir.
Do you have any questions first?
No.
Okay, now do you understand those?
Yes, sir.
All right. Is there anything you need to speak with your attorney about before we go any further?
No, sir.
And I may have asked you this, but I'm jumping back and forth here, but are you a U.S. citizen?
Yes.
All right, because I didn't check that on my list. Okay, thank you. All right, then is it your decision, Mr. Queen, to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this plea agreement?
What is it, sir?
Is it your decision to withdraw your not guilty plea and plead guilty to this charge according to the terms of the plea agreement?
What's that?
The plea agreement that you signed that we just went over.
Well, do you say yes or no? I mean, I don't understand what you're saying.
Are you going to plead guilty?
Yeah, I'm going to plead guilty.
Okay.
Sorry about that.
And you're going to do that based on this written plea agreement that we've just gone over?
Yes, sir.
Okay, that was my question. That's what you want to do?
Sorry about that.
Okay, that's what you want to do?
Yeah.
All right. Then as to the charge that reads, that on or about November 26, 2022, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11 of the Revised Code, a fifth-degree felony, carrying a possible prison term between 6 and 12 months, a fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. You can be seated. Court finds on this day in open court, defendants advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Pleas accepted, order filed. Defendants found guilty of this charge as set forth in the indictment. The court will order a pre-sentence report, and the court shall include an assessment for substance use disorder treatment and/or mental health. Sentencing hearing will be on January the 18th at 1 p.m. Now, Mr. Queen, you know, originally we started out with this being an intervention elude case, and you weren't in treatment, then you were using, and most people won't agree that I'm not intentionally cruel, but they think I am, but I try not to be. But in your case, I'm going to tell you that you look worse every time I see you. You're using way too much. You tested positive again yesterday. You tested positive the week before. You tested positive 2 weeks before that. You know, you need help. Now, have you been to see anybody to be assessed for treatment?
I've been in courthouse classes.
Pardon me?
I've been up in courthouse and classes.
At classes. Well,
yeah.
The classes don't seem to be working. So, Mr. Arjima, I'd like you to have him, you're going to go right down to probation now, as soon as we get done here. See Mr. Arjima. We're going to get an appointment for you to be talked to the clinical people down there, Ms. Sturgill or Ms. Davis, to have you assessed for residential treatment because, you know, you're still using and you haven't stopped. And, you know, in the beginning, your first 3 times, it was just marijuana. And then it continues now to be not just that, but also meth and amphetamine. And like I said, you know, you're looking worse every time I see it. And you know, that stuff's really working on your body. You're going to kill yourself if you don't slow down. If you don't stop, slowing down is not going to do it. So you need to go down there. I want you assessed. And if they tell you that you're to go, you should be in residential treatment, then that is where you're going to go. And if you don't, I'll order you to be arrested and then hold you in jail until we get you into another program. But, you know, like I said, it's striking to me how over the last few weeks, every time you come to court, you look worse. That's the meth. You know, this ain't my first rodeo. I've been doing this for 47 years, and I can tell. And you're still using. I don't believe you when you said it's been 2 weeks.
I ain't been using.
Well, and you told me before you hadn't been using, but you tested positive. So, in any event, you know, you've got a real problem, and for your own good, you need to get into treatment because what you're doing now is not doing the job. So, now, if they say that you don't need residential treatment, then I'm wrong. Okay, that's fine. But I want you to see those people because, you know, if they know what's going on here, and the fact you've been going to classes and you're not doing any better, I think that's going to change the equation. All right, so you go down there as soon as we get done here. See Mr. Arjima, he's on the screen here, and he's heard everything I've said. All right, thank you.
Thank you.
All right. All right, case number 23 CR 213, State of Ohio versus Elizabeth Margaret West. And Ms. West, you're appearing on the screen as Mark N. Woodrow.
Yes.
All right. This is a pretrial being conducted by Zoom. Ms. West, attorney, is Jacob Wagner, who was in the courtroom and just walked in the jury room on his Zoom phone. So he's present, and in representing the state is prosecuting attorney Collins. The defendant is charged in a 6-count indictment, 3 counts of trafficking and 3 counts of possession of a fentanyl-related compound. This is the first pretrial. Final pretrial set for January 3, and trial set for January 22. I see the state has provided discovery. You received that, Mr. Wagner?
I have and reviewed it, Your Honor.
All right. Well, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions, Mr. Wagner?
I do not.
Okay, well, if you do have any, they'll be due by the final pretrial as well. And has there been a written plea offer provided?
There has been, Your Honor.
Is your client aware of it, Mr. Wagner?
I can't definitively say she is, Your Honor. State gave it to me. I know she's in rehab, so I've not gotten it to her, so she probably doesn't have it.
Have you received any paperwork yet, Ms. West?
No.
All right. Well, you want to call your attorney, call him tomorrow, because I think he's going to be tied up the rest of the afternoon. You have his number?
Yes.
All right. You give him a call in the morning so you can make an appointment to talk to him, and he can, in the meantime, if you haven't got that form, was it faxed down there, Mr. Wagner?
I can get it down to her tomorrow, Judge.
All right, if you would fax it down to him. Which facility are you in, Miss West?
I'm in Foundations in Franklin Furnace.
In Franklin Furnace Foundations? Okay. All right, if you don't have that number, Mr. Wagner, Miss Sturgill does.
Yes, sir.
All right, thank you.
Thank you,
You
Your
can
Honor.
go ahead and sign off then, Miss West.
All right, thank you.
All right. Let's see. All right. Well, we had that file has been pulled to put some pleadings in it. Here it is. All right. Case number 23 CR 145, State of Ohio versus Lindsay Brooks Adams. And you are Lindsay Brooks Adams, appearing there on a screen marked Lindsay Adams.
Yes, sir.
All right. This is a final pretrial being conducted by Zoom. Ms. Adams' attorney is Sarah Barger, appearing from her office, and appearing on behalf of the prosecutor. His office is Prosecuting Attorney Collins. The defendant is charged with grand theft of a motor vehicle, and Ms. Collins has the alleged victim of the offense been notified of the time, place, and purpose of this hearing and the right to be heard?
We've attempted to notify her. We've left her voicemail.
Okay, how long ago was that?
We've left her multiple voicemails.
Okay, that's fine.
Yes.
All right.
Heather actually spoke with her. Oh, no, now she's here, Your Honor. I'm sorry, my notes aren't updated. She's actually here now.
You're not in, are you?
What case are you in?
Lindsay
I
Adams.
mean, in our,
Lindsay Adams,
Yeah.
she's actually downstairs.
She's at your office, apparently.
Yeah, she's.
yeah,
on
I was
the
about to say
table
she's here
screen.
downstairs.
That's blank.
Okay, what'd you say, Ms. Collins?
That's what I was saying. She's here downstairs.
Okay. So is she monitoring the hearing, or?
I would say on the person marked K. Conrad.
All right, okay, thank you. All right. If she wishes to be, he or she, I don't know who it is, but wishes to be heard, then just make sure you have your victim witness staff person let me know. All right. Now, Ms. Adams, I have a written plea of guilty form here. I'm going to hold up to the camera. It has a case number, your name. It says plea of guilty to the charge. You recognize that form there?
Yes, sir.
On page 3, there is a sentence about a third of the way down that reads, I enter this plea voluntarily. And next, below that immediately is a signature, which I can read. It's very clear. Thank you. Lindsay B. Adams, and it even has a date of 12/11/13. So I'm going to hold that up to the camera. Is that your signature and your the date you signed it?
Yes, sir, it is.
All right. And when you signed this, Miss Adams, did you understand that it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes.
And before I go any further, Ms. Barger, are you and your client both in agreement this matter can be conducted by Zoom rather than her in-person appearance in the courtroom?
Yes, Your Honor.
And are you okay with that, Ms. Adams?
Yes.
Okay. Are you at home or are you at a facility, treatment facility?
I'm in a treatment facility, and then I live in a sober living home, so I'm in my sober living home.
Okay,
currently.
fine. All right. And since you are not in the courtroom sitting next to your attorney, if you should have any questions during this proceeding, just tell me, and then I can put you and your attorney into what's called a breakout room on the screen, and it'll be just the two of you that will be talking, and none of the rest of us will be able to see you or hear you, okay?
Okay, thank you.
Right. Now, this agreement that you've signed states on page 1 that you're going to plead guilty to the charge of grand theft of motor vehicle under 2913.02A1, a 4-3 felony. Further states that you understand that the possible penalty for that could be 6 to 18 months imprisonment and a fine of $5,000. You understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony? Okay, I didn't hear you there.
No, I'm not. Just pretrial supervision for this. That's all I'm.
Okay, thank you.
Mhm.
Now, under the law, if you are convicted of this offense and should be sentenced to prison, once you complete the prison term, under the law, it is possible that the Adult Parole Authority would put you under what's called post-release control supervision for a period of up to 2 years under the terms that they set. They don't have to do that, but they have the option to do it if they think it's appropriate in your case. If they do, you'll be supervised under the terms they set by a parole officer, and if during that period of time you're being supervised, they determine that you have not complied, they can return you to prison even though you serve the entire term set by the court for a period of up to 9 months for any single violation, up to a maximum of half of your stated prison term for all violations, but if you commit a new felony. Then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Right? Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation, and that means you'd be supervised for a period of up to 5 years on a term set by the court by the probation department, and if during the period of time you were being supervised, they felt that you were not complying, they would file written notice of that with the court. There would be a hearing, and if you'd be entitled to have an attorney. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and sentence you to prison for a period of 6 to 18 months and fine you $5,000. And if your violation should be commission of a new felony while under community control, and you received a prison term for that new offense, that term could be ordered to be served consecutively to the term in this case. You understand that?
Yes.
Now, the charge alleges that on or about June 22, 2023 in Highland County, Ohio, you did with purpose to deprive V, which stands for victim, as to designate the person, the owner of his or her property. You knowingly obtained or exerted control over said property to wit a 2002 Mazda. A motor vehicle is defined in ORC section 4501.01 in violation of section 2913.02A1 of the Ohio Revised Code, charge of theft of a motor vehicle, a 4-3 felony with the penalties I just described. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they led you did it?
Yes, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise in trial, possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, she's been very great.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No.
Now on page 2, there are several lines printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to the indictment. State defense jointly recommend community control and referral to drug court. Defendant agrees to make restitution to Amanda Pyatt in the amount of $4,065. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
And Mrs. Collins is the alleged victim of the offense in agreement with this plea agreement and the restitution amount?
She is, Your Honor.
All right, she does not wish to be heard regarding this?
No, she does not.
All right. And Ms. Barger, you're stipulating to the amount of restitution owed to be $4,065?
We are, Your Honor. That was provided through Kelly Blue Book.
All right. Now, Ms. Adams, do you hold any license or certification from any state governmental agency that regulates any profession or occupation?
No, sir.
All right, you have certain rights you must understand before I can accept a plea from you. First of all, you have right to counsel. Ms. Barger was appointed to represent you. Her appointment wasn't simply to work the case out, but to provide any defense that may be available under the law that you would like her to provide. So, if you decide you do not want to do this, that you would rather defend against the case, she'll continue to represent you, defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Hyndman County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'll be instructed on the law by the judge, and that jury of 12 people would decide by unanimous verdict whether the state proves your guilt. Now, if you didn't have a jury trial and you didn't want to plead guilty, you could waive or give up in writing your right to have a jury trial. And in that case, you would have what's called a court or bench trial. That means that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, same as the state. So if you have witnesses, you're not certain of going to come in voluntarily. At your request, the court issues a court order, that's called a subpoena, and that forces those people to come to court to be available to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, except in one situation. If there's a jury trial, you don't testify. The judge explains to the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to show you're not guilty of this charge. In fact, under the law, you don't have to put on any evidence whatsoever. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. Now, if you change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that there are crime, that you committed that crime, and that plea waives, gives up all the rights I've just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront the witnesses against you, cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Adams?
Yes, I am.
Now, do you have any questions about the charge and the possible penalty?
No,
You understand it?
yes, I understand it.
Do you have any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
And I'm not sure I described this to you, but the matter of sentence is up to the judge, not the party. So even though there's an agreement of all concerned that you get community control, if you plead guilty, once I've heard all the information presented, I'm not required to follow that recommendation. You understand that? You muted yourself out of there, Ms. Adams. Thank you. Do you understand all that?
Yeah, I understand. Thank you.
All right. Now, do you have any questions about the plea of guilty or what it means or what the consequences of that will be?
No.
You understand them?
Yes.
Is there anything you need to speak with Ms. Barger about before we go any further?
No, I don't think so.
All right. Then do you have any questions at all before we go any further?
No, I think I'm ready to proceed, sir. Thank you.
All right. Then is it your decision to, well, and you are a U.S. citizen, correct?
Yes.
All right. Then is it your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of the plea agreement?
Yes, Your Honor.
Okay, excuse me. All right, then, as to the charge which alleges that on or about June 22, 2023 in Highland County, Ohio, that you did, with purpose to deprive B, the owner of his or her property, knowingly obtain or exert control over said property, to wit, a 2002 Mazda. Motor vehicle is defined in ORC section 4501.01. In violation of section 2913.02A1 of the Ohio Revised Code, the charge of grand theft of a motor vehicle, carrying a possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty, Your Honor.
All right, thank you. The court orders that are fines on this day in open court. Defendant was advised of all from constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Please accept an order filed. Defendant is found guilty of the charge as set forth in count 1 of the indictment. The matter is referred to the probation department for a pre-sentence report. Bond will be continued. That report will include an assessment for continued substance use disorder treatment and or mental health treatment. Sentencing hearing will be January the 18th at 1 p.m. and bond will be continued. All right. Is there
Your
anything further, counsel?
I'm actually in another trial that day at 1 o'clock.
Okay. What court?
Adams County Juvenile Court.
Is that going to be all day or just in the afternoon?
It's 1 to 4. It's all afternoon.
All right. Let's see. Probably could work to do this in the morning then. Yeah, let's go ahead and set it at 10 a.m. And that'll give you enough time then to get down here. All right, Mr. Arjima, you'll get in touch with her.
Yes, sir.
All right, thank you. All right, I've not heard anything more about Mr. Blosser, so Ms. Adams, what I'm going to ask you to do is step out, and Mr. Arjima, I don't know who all you have over there. Do you have Mr. Lauthan?
He's in person.
He's in person. All right. You have Chelsea West there?
Yes, she showed up.
All right, if you could get her in there, and then I'll do Mr. Lauthan here in person real quick.
Christina Jenkins over there.
Pardon me?
She had Christina Jenkins, she's the first pretrial.
Oh, okay. I don't know. I'm trying to jump back and forth. The thing with Blosser's throwing everything into a little tizzy here. Okay, case number 23 CR 211, State of Ohio versus James E. Lauthan. Present for the state is Assistant Prosecuting Attorney King. Present for the defendant is Jacob Wagner, and you are James E. Lauthan.
Yes, I am.
Mr. Lauthan is charged with receiving stolen property, and Mr. King, as the alleged victim of the offense, been notified of the time, place, and purpose of this hearing.
Yes, Your Honor, and is elected not to appear.
All right. Defendant, as I said, is charged with receiving stolen property, a 4th-degree felony. I believe this is a first pretrial, final pretrial set for January 3, trial set for January 25th. I believe according to the file, the state provided discovery on the 7th. You did receive that, Mr. Wagner?
We did with an offer, I showed it to my client today, Your Honor.
All right. Your discovery will be due by final pretrial if there's not a resolution before that. And if you do have any pretrial motions, they'd be due by final pretrial.
Yes, sir.
And you say your client is aware of the written plea offer?
Yes, Your Honor.
All right. All right. Are there any other matters that need to be discussed other than that?
No, sir.
No, Your Honor.
I have a note here from Mr. Arjima that Mr. Lothan didn't appear after he was transported to Hamilton County on the 21st and released on the 7th. Have you been to probation?
I wasn't released on the 7th, and I was just...
When were you released?
I was released Friday.
Last Friday?
Yeah.
That would have been the 8th.
Yeah, I was released on the 8th due to my...
You didn't report to probation then, or Monday, or Tuesday, or today, right?
Your Honor...
Is that right or wrong?
Yes,
That
that's
is right, okay. So the order was that you were to report as soon as you're released from custody, whether it be here and you had to go to Hamilton County, so you were supposed to report then after you got out. Now, if you got out late Friday afternoon, okay, I understand that. That means you come in Monday morning. You didn't come in Monday morning, you didn't come in yesterday, you didn't come in today. You came here, but you didn't report. So as soon as we're finished here, you go down there and you report.
Absolutely.
And you report once a week for 4 weeks, like I said, and you comply with all the other conditions of the pretrial order. Otherwise, if I get another notification you're not compliant, we'll issue a warrant for you to have you taken into custody until I decide whether or not you are going to comply with the bond conditions.
Understood.
You understand?
Understood.
All right. Anything further, counsel?
No, Your Honor.
No,
All
sir.
right. Head to probation.
Thank you for your time.
Straight down there, man.
Yes, sir.
If your number changes, call.
#23 CR 212, State of Ohio versus Chelsea Marie West. Present for you are Chelsea West, appearing there from the probation department.
Yes.
All right. Ms. West is attorney Dennis Kirk, and he's appearing from his office. This hearing being conducted by Zoom. Appearing from the prosecutor's office, Assistant Prosecutor Collins. The defendant's indicted on 2 counts of aggravated trafficking and aggravated possession of methamphetamine, 4th and 5th degree felony. This is a first pretrial. Final pretrial, I believe, is set for the 4th of January. I think we just changed that, and then trial set for the 22nd. Now, I see the state's provided discovery and filed a request for discovery. You did receive the state's discovery, Mr. Kirk?
Yes, Your Honor.
All right, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this time.
And has there been a written plea offer?
Yes, Your Honor.
All right, is your client aware of that, Mr. Kirk?
She is not. I need her to contact my office. We have not heard from her. We did reach out to her, send her a letter, but have not heard back. So would like her to contact my office as soon as possible.
You have, did you get that letter, Ms. West?
Yeah, yes, I just
All right,
got
you
it.
get a hold of him, call him tomorrow morning, okay?
Yeah, okay.
All right, thank you. All right, Mr. Arjima, I see Mr. Blosser's back, so let's get Ms. Brooks back in there.
Penalty.
Yeah, we talked about that because we talked about the reduction.
Okay. Oh, that's where we were. I was asking if you were in agreement with that. Yeah, okay.
Yes, and I am.
Yeah, okay.
I am.
We'll get your client back in here and then we'll get back on it. We're on the record, but we don't have your client yet.
Thank you.
Okay, Ms. Brooks, if you can unmute your screen there. Thank you. All right, we're back on the record. Mr. Blosser's now back on Zoom. And Ms. Brooks is at the Highland County Probation Department. Counsel for the state is also present by Zoom. And we were going through the plea agreement, Ms. Brooks, and I believe where we were is we had discussed the reduction from the second degree felony to a third degree felony, and it was reduced actually 2 levels of bulk to 50 to 200. But what Mrs. Collins was indicating was that made it a low tier felony in the third degree. If it was 200 to 400, it would have been a high level third degree felony, or high tier, I believe.
It's not necessarily that it's a high tier, it's that it's mandatory prison.
Mandatory prison, okay. Still would have been a third degree felony, but a mandatory.
Exactly.
So that's the difference between 50 to 200 and 200 to 400.
Yes.
You agree with that, Mr. Blosser?
I do, Your Honor.
Okay. And you're in agreement with the amendment to the indictment to reduce it by amending the amount?
I am.
All right. Now, so Ms. Brooks, you understand what happened here is the reduction is to a third degree felony, which makes you eligible for community control. As charged, it would have been a mandatory prison term. And if it had been reduced by 1 level of bulk, it would still be mandatory and have been a third degree instead of a second. But by reducing it to 2 levels of the amount involved, it makes it eligible for community control or probation. And the sentence for that would be between 9 and 36 months would be possible. And there are certain ranges in between the 9 and 36 months that the court can impose. There's a fine of $10,000 and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes.
Okay. Now, are you currently on probation, community control, parole, or post-release control for a felony?
No.
Now, under the law, if you should, are you facing any felony charges anywhere else?
No.
All right. Now, if you plead guilty and are sentenced to prison, then upon completion of that, it is term, it's possible the adult parole authority would exercise the option under the law to put you under post-release control supervision for a period of up to 2 years under the terms they set. If during that period of time you're being supervised, they determined you were not complying, they would have the right to return you to prison, make you serve an additional period of up to 9 months for any single violation of the terms, up to a maximum of half of your prison term for all violations. However, if you should be convicted of a new felony while under post-release control supervision, then in addition, whatever sentence the judge in the new case can impose, that judge can also sentence you to an additional term of a year, whatever time is left on that period of post-release control for committing the new felony while under post-release control in this case. Do you understand that?
Yes, sir.
Under the law, the court's not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, which means instead of going to prison, you'd be put under supervision of a probation officer for a period of up to 5 years. And if during that period of time they determined that you had failed to comply, or they felt you had failed to comply, they would file written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome was that you had failed to comply, then at that time the court could revoke the community control, sentence you to a prison term between 9 and 36 months, and I could also fine you $10,000. And if you were convicted of a new felony while under post-release control in this case, under community control in this case, then the judge in that case could sentence you to a prison term consecutive to any term that was imposed in this case. Do you understand that?
Yes, sir.
All right. Now, the charge alleges in count 26, as amended, that on or about May 19, 2022 in Highland County, Ohio, Justin Kyle Anderson, Travis James Zuber, you, Aubrey G. Utley, and Richard Scowden did knowingly obtain, possess, or use a Schedule I controlled substance, to wit hashish in liquid form, the amount equal to or exceeding 50 grams, but less than 200 grams, in violation of Section 2925.11 which, as I said, reduces that potential charge of a third-degree felony and makes it eligible for community control. Do you understand what it is that that charge is, what the state said you did, and when, where, and how they led you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you could try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to get you to plead guilty here today?
No.
Now, on page 2, there are several lines printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 26 as amended to a felony in the third degree by amending the weight of hashish in liquid form to an amount equal to or exceeding 50 grams but less than 200 grams. State will dismiss count 25. State and defense jointly recommend community control and substance abuse treatment. Defendant agrees to cooperate fully with the task force. Defendant agrees to cooperate fully in the prosecution of all co-defendants, including testimony. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentence is up to the judge, not to the parties. And so, even though the parties are agreeing that the sentence ought to be community control, that's not binding on the court. So, if you plead guilty, once I've heard all the information submitted, I don't have to follow that recommendation. I could determine that that's not the appropriate sentence and impose a sentence of imprisonment between 9 and 36 months, fine of $10,000, and suspend your license for 6 months to 5 years. You understand that?
Yes, sir.
Do you hold any license or certification from any state governmental agency that regulates any profession or occupation in this state?
No.
Now, you have certain rights you must understand before I can accept your plea. First, you have a right to counsel. Mr. Blosser was appointed to represent you not simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide you don't want to plead guilty, he'll continue to defend you and represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Under the Constitution, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'd be instructed on the law by the judge, and that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination, the purpose of which would be to bring out evidence that might help your side of the case. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, you request court issues a subpoena, which is a court order. It forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into trial to testify against you. You understand that?
Yes.
Under the Constitution, you have privilege against self-incrimination. This means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, any time. No one can even comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, you're presumed innocent of the charge until proven guilty by the state on every essential element of the offense charge. So, the burden of proof isn't on you to try to prove you're not guilty. The burden's on the state to prove that you are, and they must do that by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally you pled not guilty. You not guilty plea denied the allegations, and the indictment denied you committed any crime, and exercised or invoked all of the rights that I've just described. If you change your plea from not guilty to guilty, that is the opposite of guilty, not guilty. The guilty plea admits the allegations, admits that they're a crime, and that plea waives, gives up all the rights that I've described for you today, except the right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury trial, would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. Would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. Would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. It waives or gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up all of your right to file an appeal. Now, if I should sentence you to maximum sentence or under other limited circumstances, there could be a right to appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes,
And are you a U.S. citizen?
I am.
Now, do you have any questions about the charge, the possible penalties?
No, sir.
You understand them?
Yep.
Do you have any questions about the plea agreement?
No,
You understand it?
I do.
And again, you understand the recommendation as to sentence is not binding on the court.
Yes,
You have any questions about the constitutional rights I've explained?
I do not.
You understand them?
Yes,
You have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
no,
Is there anything you need to speak with your attorney about before we go any further?
no,
Then as to is your decision to withdraw your not guilty plea and plead guilty to count 26 as amended pursuant to the terms of the plea agreement? Is that your decision?
yes,
Then as to the amended charge in count 26, which alleges that on or about May 19, 2022 in Highland County, Ohio, Justin Kyle Anderson, Travis James Zuber, you, Aubrey G. Utley, and Richard A. Scowden did knowingly obtain, possess, or use a Schedule I controlled substance, to wit hashish in liquid form, an amount equal to or exceeding 50 grams but less than 200 grams, in violation of Section 2925.11 Ohio Revised Code. The charge of possession of hashish under 2925.11 of the Ohio Revised Code, a third-degree felony, carrying a possible prison term between 9 and 36 months, fine of $10,000, and a license suspension of 6 months to 5 years. How do you plead? How do you plead?
guilty.
All right. Court finds on this day in open court, defendants advised of all their constitutional rights, made a no intelligent voluntary waiver of those pursuant to criminal 11. Please accept an order filed. Defendant guilty of count 26 as amended. Count 25 is dismissed as to this defendant. Pre-sentence investigation is ordered. That will include an assessment for substance use disorder treatment and or mental health assessment and possible treatment. Sentencing will be set for February the 7th at 9 a.m. Bond will be continued. And count 25 is dismissed as to this defendant. All right, is there anything further, counsel?
And Jeff, can you just have Bridget get in contact with the office so that she can come in before her sentencing?
Absolutely, thank you.
Thank you.
All right. Have a good day, everyone.
All right, we have Christina Jenkins down there at the probation department.
Yes, Your Honor.
Could you send her in, please?
Yes.
All right, and then Mr. Krager will do you next, your case next. All right, Ms. Jenkins, if you could unmute yourself on the computer there. All right, thank you. All right, this is case number 23CR214, State of Ohio versus Christina K. Jenkins. You are Christina K. Jenkins, appearing there from the probation department?
Yes, sir.
All right, this hearing is being conducted by Zoom as a pretrial. Ms. Jenkins appearing from the probation department. Her attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office, Prosecutor Attorney Collins. Bench charged with 2 counts of trafficking, 2 counts of possession of fentanyl-related compound. I believe this is a first pretrial, final pretrial set for the 3rd of January. Trial date is set for January 25. See, the state's provided bill particulars and discovery, and you received that, Ms. Witt?
I have, Your Honor.
All right, I don't see your discovery, so yours is due by the final pretrial. Do you anticipate any pretrial motions?
No, none at this time.
All right, well, if there are any, they'd be by final pretrial. And has there been a written plea offer provided?
There has been.
Is your client aware of that, Ms. Witt?
She is.
Yeah. All right, is there any other matters that need to be discussed at this time?
No, Your Honor.
All right, then your next hearing will be January the 3rd, Ms. Jenkins. Thank you.
Thank you.
All right, Justin Krager. This is a case of State of Ohio versus Jason R. Krager. And you're Jason R. Krager, appearing on the screen marked Jason Krager.
Yes, sir.
All right, this is a pretrial being conducted by Zoom. Mr. Krager's attorney is Jacob Wagner, appearing on Zoom. Appearing by Zoom also is the prosecuting attorney Collins, representing the state. Defendant's charged with strangulation and domestic violence. I believe this, excuse me, this is a first pretrial, final pretrial set for January 3. Trial date is set for January 25. Now, Ms. Collins, has the alleged victim of this offense been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, we've actually just spoken with her today, and she has not appeared.
All right. Now, see, there was a request for discovery filed. Just looks like it was just filed today, so no discovery's taken place yet?
No, sir.
All right. Well, yours will be due by the final pretrial, Mr. Wagner, and also any pretrial motions at this point. Do you anticipate any pretrial motions?
I do not, Your Honor. This is a case where I was privately retained and I did the prelim, so I'm kind of up to speed on the case already.
All right. Well, when there's a request for discovery, then the state will need to provide your written plea offer at that point. Now, is there anything further that needs to be discussed at this time?
Only Your Honor, and I didn't discuss this with Ms. Collins beforehand, so I do apologize. Your Honor, my client is on an OR bond, but he also has EMHA. He had that out of a municipal court case. The municipal court has released the EMHA. We're just down to this court's condition. I believe he's under a CPO through the Domestic Relations Court and the victim in this case. So there's obviously other things in line that would restrict his contact. We would just ask the court if you would consider taking off the EMHA, Your Honor.
No. Offense of this type? Absolutely not. Anything further?
Nope.
All right. Thank you. All right. representing the state, Assistant Prosecutor King, representing the defendant's attorney Jacob Wagner. And are you James S. Festro?
Yes.
All right. Mr. Festro is charged with 6 co-defendants in a multi-count indictment. I believe he's just charged in 2 counts, 30 and 31, permitting drug abuse and a forfeiture. Now, discovery looks like it's been provided by both sides. Is that completed as far as everyone knows?
Does from the state, Your Honor.
From us as well, unless we supplement later, but yes.
You have no pretrial motions?
Not at this time.
Okay, if you do, they'll be due by the final pretrial. And has there been a written plea offer provided?
It has, and related.
Okay. Now, I don't recall when this case is set for trial. I see there's been a request. Oh, set for trial January the 8th. There's a motion to continue. And a waiver of time. The state's aware of that, Mr. King?
Yes, Your Honor.
All right, Mr. Wagner?
Your Honor, we would just ask time to continue this case, not making any excuse whatsoever. Just got done with a big 2-day case in this courtroom. This is a case where there's so much evidence I had to physically go out and buy a new Terra drive, which that was new to me, to download all the evidence. Still going through it. I just want time to properly prepare in this case, Your Honor.
Mr. King?
State has no objection, Your Honor.
Just out of curiosity, does he have the discovery for the entire case or just what's relevant to this case?
Everything.
Okay, well, that's the problem because he's only charged with 2 counts out of 30-some. 32. So in the future, is there a way to hone that down? Yeah.
Judge.
If I may, Your Honor. And again, I don't know. I mean, I actually appreciate the state giving me this. I don't know who's going to start pointing fingers which ways. So dots need to get connected on who's going to start pointing fingers. So I do appreciate the state giving me that, but that's what's taking me so much time.
Well, I'm glad everybody's getting along, but you know, when if there's only 2 counts for one defendant, I don't see why. You know, I mean, I guess you can have it, but you know, I don't know why we can't just identify what's relevant to this particular charge.
Your Honor, a lot of it is relevant to him. What we're alleging is that his building is the stash house for the operation.
Okay. All right.
It's not just one transaction.
Okay, I see it is over a period of a year. All right. Well, I think I continue the co-defendant's case, Mr. Anderson, till March. But I think we're going to have to try these cases separately from what it sounds like to me.
Yes.
So I will continue the trial to February 29 at 8 o'clock.
Thank you, sir.
All right. And let's see, we still have a pretrial set, I believe.
I think this is the last one, Your Honor.
This is the final.
This is the final pretrial? All right. Well, I'm going to go ahead and reset it for a final pretrial so we have a time to discuss whether or not there's going to be a plea and if there's going to be a rejection. That can be put on record. So we'll set this for pretrial on February the 1st at 2 p.m. So you need to be back here on February the 1st, Mr. Festro. All right. All right. Anything further, Counsel?
No, Your Honor.
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Wilkerson there at the probation department? You'll need to unmute yourself.
Okay.
All right, this is case number 23 CR 157, State of Ohio versus Deandra Wilkerson. This is a pretrial being conducted by Zoom. She's appearing from the probation department. Her attorney is Catherine Hapner. Appearing from her office, appearing from the prosecutor's office is Prosecutor Collins. Defendant is charged with 1 count of aggravated possession of methamphetamine, a 5th degree felony. I believe this is a first pretrial. Final pretrial is set for, actually this is final pretrial. The trial is set for January the 11th. All right, is discovery, I see the state's request for discovery. Ms. Hapner, I don't see where you've complied.
I have not, Your Honor. After my discussions with Ms. Wilkerson, she intends to accept the state's plea offer. I just need to get her to sign the plea form.
Oh, okay. All right. Then, Ms. Wilkerson, you need to get in touch with your attorney tomorrow morning and get the time for you to talk with her so that this can get scheduled.
Okay, yes, sir.
All right. And so need to do that as quickly as possible because we're running out of time this year. And, the week after Christmas won't be much going on, so we need to get it done next week.
Okay, I'll be there first thing in the morning.
All right. All right. Anything further from counsel?
No, Your Honor.
All right. Thank you.
Okay. Thanks, sir.
All right. Aubrey Utley. Let's do him first then. Mr. Arjima probably can't hear me. He's en route. All right. Yeah. Case number 23 CR 178, State of Ohio versus Norman Benson. And you're Norman Benson, appearing there from the probation department?
Yes.
All right. This is a final pretrial. Mr. Benson's charged with 3 counts of aggravated trafficking, 3 counts of aggravated possession of methamphetamine. His attorney is William Armentrout, and representing the state is Mrs. Collins. The defendant is appearing by Zoom from the probation department. I think this is the final pretrial. Trial is set for January the 8th. Is discovery complete? We're ready for trial, counsel?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. Has there been a written plea offer provided?
There has been.
And he's aware of it, Your Honor.
All right. Is he? Okay. We have a trial date coming up, so we next week would probably be the end of the time for a plea because of the holidays. So if we're going to get anything done, we need to know next week.
That'd be fine, Your Honor.
All right.
Thank you, Your Honor.
All right. We'll go ahead and call James Brown now while I've got Mr. Armentrout here. All right, case number 23 CR 189, State of Ohio. Have we heard from James Brown today? No? Okay. State of Ohio versus James B. Brown Jr. This is a pretrial was set today at 2:30. It is now 3:10. Mr. Brown's attorney, William Armentrout, and the prosecuting attorney, Annika Collins, are appearing by Zoom. Defendant was to appear in person. He is not. I have a fax from Mr. Arjima this morning that says that Mr. Brown reported on December the 6th. On December 11th, he left her a voicemail stating he was in the hospital all weekend, has yet to provide any medical documentation. So, Mr. Armentrout, you have you had any contact with Mr. Brown?
No, Your Honor, I tried both numbers that I had today. One didn't work. The other one, it came up his voice on the voicemail, but the mailbox was full.
Do you have anybody have any contact, Mr. Arjima or Mr. Armentrout, numbers for his mother, which I believe is Berryman, Miss Berryman, and his brother, which half-brother, and I forget his last name is also Berryman, because they have both called here before.
That was the 876 number that I had, Eric. Was that yours? You're muted, Eric.
I'm pulling them up now. Yeah, I have an 876 number. I have another number for it's a second phone for Alice, his mom.
That's his mother, Alice Berryman. She's been in court with him before.
You want that number, Bill?
What is it?
740-505-4317.
All right. I'm going to issue a warrant for his arrest. Getting real tired of this stuff. I know he's got legitimate medical problems, or at least he appears to have, but every time he shows up late, or he doesn't call. He used to call, now he's just not showing up. So case is put on the inactive docket, capious will issue. And we'll see what's going to happen the next time. Mr. Armentrout, when you do get in touch with, or when they do contact him, because I assume when he gets arrested, you'll be getting phone calls. I want to see proof of all this stuff. Because this is just getting to be out of hand. So,
Eric, was that
it's gonna
740?
the sheriff may not like it, but I may just have to have them sit with him in a medical, in a hospital. And we'll, once we get him, we'll put him on a real quick time. We'll have a final pretrial that day, and I'll set the hearing in 2 weeks, and we'll try the case and get it decided, because I'm really getting tired of this. It's ridiculous. So, all right. Okay, now, we have Ms. Utley back. All right, this is case number 23 CR 196. I'm sorry, from the probation department. From the probation department?
Yes.
All right. I thought you'd bring me a message from Mr. Brown.
No,
Okay.
that one didn't have anything on it. I think
All right.
I took it by mistake.
No, he's got a warrant on it.
Oh, that is?
Yeah. All right. This is case number 23 CR 196, State of Ohio versus Aubrey G. Utley. And Ms. Utley's appearing from the probation department. Her attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office, Prosecutor Collins. This hearing is being conducted by Zoom. And this is a plea hearing. And Mr. Kirk, you and your client both agree that this matter can be conducted by Zoom rather than an in-person appearance?
Yes, Your Honor.
You're all right with that, Ms. Utley?
Yes.
Right now, if any time during this hearing you need to just talk with him, you just let me know, and I'll put you and him into a breakout room, and the two of you can talk. No one else will be able to see you or hear you. All right? Now, Ms. Utley is charged with 6 co-defendants in a multi-count indictment, and looks like she is charged in counts 25 and 26. And 26, let's see, this is a co-defendant to, let's see, Bridget Brooks, okay. And she's charged with possession of hashish, a second-degree felony. There has been a plea form presented. Ms. Utley says you're going to plead guilty to amended count 26. That would reduce that to a third-degree felony from its current second-degree felony, which is a mandatory prison term. That makes it subject to a lower prison term and makes it probationable. Now, I'm going to show you the first page, which says you're going to plead guilty. Lost my screen up there, guys. It says you're going to plead guilty. Do you see your name and everything there?
Yes.
All right. Now, on page 3, there is a sentence about halfway down that says, I enter this plea voluntarily. Below that is a signature, which appears to be Aubrey Utley. I'm going to hold that up to the screen and ask if that is your signature.
Yes.
When did you sign this document?
I think it was like about a week and a half ago.
And did you go over it with your attorney before you signed it?
Yes.
When you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step of your case will be a sentencing hearing?
Yes.
And did you have enough time to fully consider this matter before making this decision?
Yes.
Did you enter into this plea agreement and sign it voluntarily?
Yes.
And is that still what you want to do today?
Yes.
Now, the agreement says you're going to plead guilty to the amended charge in count 26, possession of hashish liquid, under 2925.11 of the Ohio Revised Code, a third-degree felony. Further states that you understand that the prison term for that could be between 9 and 36 months and a fine of up to $10,000. And there could also be a license suspension of 6 months to 5 years. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently under probation or community control in any jurisdiction?
No.
Or parole or post-release control?
No.
Now, under the law, if you're convicted of this offense, if you're sentenced to prison, once that prison term is complete, the Adult Parole Authority may, at their option, put you under what's called post-release control for a period of up to 5 years on a term set by the court. If during that period of time they determine that you're not compliant, they would file written notice that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and sentence you to between 9 and 36 months and fine you $10,000. And if you committed a new felony as a result of that while under post-release or under community control in this case, and were sentenced to prison on that charge could also be served or to be served consecutively to the charge in this case. You understand that?
Yes.
All right, now the charge currently reads that on or about May 19, 2022 in Highland County, Ohio, that Justin Kyle Anderson, Travis James Zuber, Bridget M. Brooks, you, and Richard Scowden did knowingly obtain, possess, or use a Schedule I controlled substance to wit hashish in liquid form in amount equal to or exceeding 400 grams. And that amount is going to be reduced to make it a third-degree felony, both of which would be a violation of Section 2925.11. You understand what it is you're charged with, what the state said you did, when, where, and how they led you did it?
Yes.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible offenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Say that again.
Have you talked about the case with your attorney, what the charge is, what you might try to argue at trial, what possible outcomes of a trial would be?
Yes.
And are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, on page 2, there are several lines that are printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 26 as amended to a felony of the third degree. by amending the weight of hashish in liquid form to an amount equal to or exceeding 50 grams but less than 200 grams. State will dismiss count 25. State and defense jointly recommend community control and substance abuse treatment. Defendant agrees to cooperate fully with the task force. Defendant agrees to cooperate fully with the prosecution of all co-defendants, including testimony. Now, is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentencing is up to the judge, not the parties. And so even though there's an agreement as to what the sentence should be, the court is not bound by that. So if you plead guilty, the court, once it's heard all the information that's presented, may decide that that's not the correct sentence and that you should be sentenced to a prison term, fined, and have your license suspended. You understand that?
Yes.
All right, now, you have, well, do you hold any license or certification from any state professional, a board that regulates any professional or trade in this state?
No.
All right, now you have certain constitutional rights you must understand before you can accept the plea. First, you have a right to have an attorney, and I appointed Mr. Kirk to represent you. Now, that appointment wasn't simply to work the case out, but provide any defense that may be available to you under the law that you would like him to provide. So if you decide you do not want to do this, that you want to defend against this case, he'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. You would be instructed on the law. They would be instructed on the law by the judge. And then that jury of 12 people would have to decide whether or not the state proved your guilt by a unanimous verdict, meaning all 12 would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine through your attorney. What that means, that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, you request court issues a court order, that's called a subpoena. And that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain can come in voluntarily at your request, the court issues a court order, that's a subpoena, and that forces those people to come to court to be able to testify, even though they don't want to be here, which is the same way the state's witnesses are forced to come in court and testify against you. Do you understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. That means you're not required to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally entered a plea of not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights that I've just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits that there are crime, that you committed that crime, and that plea waives, gives up all of the rights that I've just described for you today, except your right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and cross-examine them through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you the same as the state. It waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what you find to give them. And it would waive or give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you feel you may have had up until this point in the case. Now, if I sentence you the maximum sentence or under the certain circumstances, you could file an appeal, but that had to be filed in 30 days or sentencing interim being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge, the possible penalties?
No, sir.
You understand them?
Yes.
Any questions about the plea of guilty? What it means, what will happen if you have that plea?
No.
You have any questions about the plea agreement?
No.
You understand it?
Yes, sir.
You understand that it's the recommendation on sentencing is not binding on the court?
Yes.
Have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
And are you a U.S. citizen?
Yes.
All right. Do you have any questions you would like to speak to your attorney about before we go any further?
No, thank you.
Then are you ready to proceed with the agreement and enter a plea of guilty?
Yes.
All right. Now, you have no questions about anything then?
No.
All right, then as to the charge, which as amended would read that on or about May 19, 2022 in Highland County, Ohio, Justin Kyle Anderson, Travis James Zuber, Bridget M. Brooks, you, and Richard Scowden did knowingly obtain, possess, or use a Schedule I controlled substance, to wit hashish in liquid form, the amount equal to or exceeding 50 grams but less than 200 grams, in violation of Section 2925.11 of the Ohio Revised Code, charge of possession of hashish in violation of Section 2925.11 of the Ohio Revised Code, third-degree felony, with the penalties I've previously described: 9 to 36 months in prison, fine of $10,000, possible life suspension of 6 months to 5 years. How do you plead?
Guilty.
Right, the court finds on this day in open court, defendant was provides all the constitutional rights to make no intelligent, voluntary way of the same pursuant to criminal 11. Please accept an order filed. Defendant is found guilty of the charge as amended in count 26. Count 25 is dismissed as to this defendant, and pre-sentence is ordered. That will include an assessment for substance use disorder and or mental health treatment, and sentencing will be on February the 7th at 9 a.m. All right, is there anything further from counsel?
Mr. Kirk, you need to have Ms. Utley contact our office.
Okay.
All right, then see the probation officer and keep in touch with your attorney. Thank you.
Thank you.
All right, who's the individual on the screen marked M. Stafford? Yeah, go ahead and change any of those and let me mark that in my folder here. 14.
Yeah.
At one time?
At 1, because we have something
All right.
in the morning.
Okay.
Thank you.
All right, this is case number 23 CR 165, State of Ohio versus Shane Everett Cottrell. And you're Shane Everett Cottrell, appearing on the screen marked M. Stafford?
Yes.
All right. This is a pretrial being conducted by Zoom. Mr. Cottrell's attorney is Catherine Hapner. She's appearing by Zoom from her office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. This is the first pretrial, final pretrial set for January 17, and we have a trial on February 15. I see the state has provided discovery and did request discovery. And Ms. Hapner, I don't see your compliance. Have you filed yet?
I have not yet.
All right. Well, it'll be due by the final pretrial. And do you anticipate any pretrial motions?
Not at this time.
Well, if there are any, they'll be due by final pretrial as well. And has there been a written plea offer?
There has been.
Yeah, I have received that offer, but Shane, what facility are you at so I can transmit this to you?
The Rulon Center in Chillicothe.
Okay, I will get you your discovery and the plea offer to you.
Okay.
All right, is there any other matters then to discuss at this time?
No, Your Honor.
All right, we'll see your next pretrial. Mr. Cottrell will probably do it by Zoom as well. So you can go ahead and log off. Thank you.
Thank you.
All right. Yeah, 23 CR 187. Case number 23 CR 187, State of Ohio versus Cameron D. Renner. Your Cameron D. Renner appearing on the screen marked Tiffany Renner.
Yes, sir.
All right, this is a hearing being conducted by Zoom. Mr. Renner's attorney is Scott Wood, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. Mr. Renner's indicted along with a co-defendant for complicity, aggravated robbery, felonious assault, having weapon under disability, and 2 gun specs. Ms. Collins, has the alleged victim or victims of these offenses been notified of the time, place, and purpose of this hearing?
Yes, he has been notified, Your Honor, and he is not in attendance.
There's just one singular alleged victim?
Yes.
All right. All right, this is a final pretrial. We have a trial set for January the 22nd. See, the state provided discovery and requested discovery in November 20. I don't see a compliance, Mr. Woods. Have you filed your compliance yet?
Your Honor, we have no discovery, and I filed that with my initial discovery request that we had no reciprocal discovery.
Oh, all right.
I believe that was,
I don't have that.
I believe that was filed October 27th, Your Honor.
Well, you should have given me the winning lottery numbers then, if you can predict the future. I've never seen that done before in arraignment.
We didn't get a copy of that either in the stuff that you enclosed to us with your appearance notice, bill of particulars and all that. That's not in there.
You didn't get my demand for discovery?
We got your demand. He asked for your compliance.
It's contained in that demand. If you look at the last paragraph, defendant pursuant to civil rule, should say criminal rule 16H submits to the state that the defendant has no evidence to provide to the state at this time.
All right. Well, then the question is this. Has that changed, Mr. Woods, since you got the state's discovery?
It has not, Your Honor.
All right. Because I don't want to have any last-minute stuff, so...
I understand.
You know, all right. Now, you've not filed any pretrial motions, correct?
That's correct, Your Honor.
All right. Well, those were due by today, so... and did the defendant receive a written plea offer?
We provided it on
All right,
November the 24th.
All right. Well, Mr. Wood, the court's policy is that if a plea agreement is not going to be accepted, that it needs to be signed and rejected, and then you keep a copy, and the prosecutor gets a copy. I don't get it because I don't need to, nor do I want to know what it was. That's just simply so each attorney has a record that it was discussed in the case, and that should become an issue in the future for the protection of all parties. The court also has a policy that any plea agreement needs to be completed and on record at least 14 days prior to the trial date, because once we send out jury notices and so forth and we clear the docket for that trial, I don't let people come in last minute plead guilty, because that's how courts get their trial dockets in trouble, and I'm not going to let that happen. So in the event there's going to be the matter worked out, it'll need to be on record no later than January the 8th, just so you know.
Understood, Your Honor.
All right, or actually be the 9th, because, well, I don't know what to see. I don't have next year's calendar, but I think the 8th is a Tuesday.
I believe that's...
Yeah, okay. All right, any other matters that need to be discussed then at this time?
No, Your Honor, thank you.
All right, Mrs. Collins?
No, I was just gonna say the 8th is a Monday.
It's a Monday? Okay,
Yes.
well, oh yeah, that's right, a week after New Year's, all right. Okay, so Monday would be, that'd be 2 weeks, all right. All right, so make sure you stay in touch, Mr. Renner, with your counsel, and if we don't have anything to notify and on the docket by January the 8th, then it'll be, soon will be a trial, and you'll be here at 8 o'clock that morning. All right, thank you.
Thank you, Your Honor.
All right, let's see, who do we have there at the probation department? Case number 22 CR 151, State of Ohio versus Christopher J. Eaton. You're Christopher J. Eaton, appearing there from the probation department.
Yes.
All right. This is a hearing being conducted by Zoom, pre-trial. Mr. Eaton is appearing from the probation department. His attorney is Sarah Barger, appearing from her office. Appearing on behalf of the state is Prosecuting Attorney Collins. Defendant is indicted with 3 co-defendants in a multi-count indictment for the various defendants. He is charged in counts 15 and 16 with aggravated trafficking and possession of methamphetamine. Now, I have a plea of guilty form here, Mr. Eaton, which indicates you're going to withdraw your not guilty plea and plead guilty. I'm going to hold that up to the camera, and it has your name and case number, and ask if you can see that and if you recognize that form.
Yes.
And on page 3, there is a sentence that reads, I enter this plea voluntarily. Immediately below that appears to be Chris Eaton, 11/29/23. And is that your signature? And did you date that date?
Yes.
And is that the date that you signed this document?
Yes.
When you signed it, did you understand that it's an agreement to plead guilty, which means there won't be a trial? The next step would be a sentencing hearing?
Yeah.
And did you have enough time to fully consider the matter before making this decision?
Mm-hmm. Yeah.
And
we talked.
All right. And did you enter into this and sign this document voluntarily?
Yeah.
And is this still what you want to do?
Yeah.
All right. The agreement states on page 1 you're going to plead guilty to count 15, aggravated trafficking of methamphetamine under 2925.03A1, a 4th-degree felony. It further states that you understand that the maximum penalty on this could be 6 to 18 months in prison, fine of $5,000, and life suspension of 6 months to 5 years. Do you understand that?
Yeah.
And are you facing any felony charges anywhere else?
No.
And are you currently on probation, community control, parole, or post-release control for a felony?
I mean, just for, I guess, on this.
But this is pre-trial, but you've not been convicted and on probation for another felony?
No.
All right. Under the law, Mr. Eaton, if you're convicted of this offense and sentenced to prison, upon completion of that prison term, you could be put under post-release control supervision by the Adult Parole Authority for a period of up to 2 years. And if during that period of time they determine that you had not complied, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. However, if you committed a felony, then in addition to whatever sentence a judge in that new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yeah.
Now, under the law, I'm not required to sentence you to prison. I can impose what's called community control or probation, and that means that instead of going to prison, you'd be put under supervision of a probation officer for a period of up to 5 years in a term set by the court. If during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court. There would be a hearing, be entitled to have an attorney. If the outcome of that hearing was that you'd failed to comply, then at that time, the court could revoke your community control and sentence you to prison for 6 to 18 months, fine you $5,000. If you were sentenced and had committed another felony while under community control, then in addition, whatever sentence that could be imposed in that case, and it could be ordered to be served consecutive to the sentence in this case. You understand that?
Yeah.
Now, the indictment alleges in count 15 that on or about November 15, 2021 in this county, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1 of the Ohio Revised Code. That's a fourth-degree felony with the penalties I've just described. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yeah.
Have you discussed the charge, the evidence in the case, the issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Oh, say that again.
Have you talked about your case and what you're charged with, and you know what kind of defense you might try to bring up at trial, and what might happen if you go to trial?
Yes.
Are you satisfied with her advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty?
No, sir.
Now, on page 2, it says that the defendant will enter a plea of guilty to count 15. State will dismiss count 16. State defense jointly recommend community control, substance abuse treatment. Defendant agrees to cooperate fully with the task force and repay by money to the task force in the amount of $60. Is that your understanding of the agreement?
Yes.
Did anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. So if you plead guilty, the court is not bound by that sentencing recommendation and could decide that's not the correct sentence and sentence you to prison, fine you, and suspend your license. You understand that?
Yes.
You hold any kind of a license or certification from any state governmental agency that regulates any occupation or profession in this case, in this state?
No.
Right, now you have certain constitutional rights you must understand before the court can accept your plea. First of all, you have a right to have counsel, and Ms. Barger was appointed to represent you, not simply to work the case out, but to provide any defense that may be available to you under the law that you would like her to provide. So, if you decide that you do not want to plead guilty, she'll continue to represent you and defend you, including in trial, if that's what you want. Do you understand that?
Yes.
All right, now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of people that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and that jury would have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that instead of a jury, a judge would hear the evidence, apply the law, and decide whether or not the state proves your guilt. You understand that?
Yes.
Under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means, that the witnesses against you have to come into court, testify in open court, in public, in front of you and your attorney, and anyone else that may be there. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request to court issues a court order is called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. You understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it, except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it, for any purpose. Do you understand that?
Yes.
All right, now, under the Constitution, you're presumed innocent till proven guilty by the state of Ohio on every essential element of the offense charged. So, what that means is that you're not required to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed a crime, and it exercised or revoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of not guilty plea. A guilty plea will admit the allegation in the indictment, admit that there are crime, that you committed that crime, and that plea will waive or give up all the rights I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty will waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and cross-examine through your attorney, to waive or give up your right to use the power of the court to compel and force witnesses to come to court to testify for you, the same as the state. It'll waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. It will subject you to being sentenced immediately by the court. Finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you the maximum sentence, under certain circumstances to file an appeal, that would have to be filed within 30 days, every sentencing entry being filed. You understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge, the possible penalty?
No, sir.
You understand it?
Yeah.
Have any questions about the plea agreement?
No, I went and got I'm working on an assessment. I got the time and date when I'm supposed to go.
All right, but you understand the agreement?
Yes.
All right. And again, you understand the recommendation on sentencing is not binding on the judge?
Yes.
You understand the constitutional rights I've explained?
Yes.
And you understand the plea of guilty, what it means, and what will happen if you enter that plea?
Yes.
All right, then is it your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of the plea agreement we've just gone over? Is it your decision you're going to plead guilty then to the charge in count 15?
Yeah. Yes.
All right, then as to the plea, as a charge in count 15, which alleges that on or about November 15, 2021 in this county, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1, charge of aggravated trafficking in methamphetamine, a fourth-degree felony, carrying possible prison term between 6 and 18 months, fine of $5,000, and a license suspension for 6 months to 5 years. How do you plead?
Guilty.
All right. Court finds on this date, open court, defendant's advised of all his constitutional rights, made no intelligent voluntary waiver of the same. Sentence from 11 pleas accepted or filed. Defendant's found guilty of count 15 as charged. Count 16 is dismissed. Court will refer the matter for a pre-sentence report, and the sentencing hearing will be set for February the 14th. I would note to counsel that I said earlier the 7th, but they're actually the 14th. So on those other cases, assignment notice is going to come back the 14th. And it's going to be at 1 o'clock. Bond will be continued. So stay in touch with the probation department. Make sure you get your assessment done. Mr. Arjima will want to see you to get your pre-sentence appointment set up. All right. Anything further from counsel?
No, Your Honor.
All right. Thank you.
No, Your Honor.
All right. Is Mr. Pig there at your office, Mr. Arjima? Robinson. Case number 23-0163, State of Ohio versus Robinson. Ms. Robinson's charged with illegal conveyance and aggravated possession of methamphetamine. The matter was set for pretrial on November 15th, and then on today for final pretrial. And she was to employ counsel and November 15th, and can't remember if she was here or not.
She was, Your Honor.
She was?
Yes.
And she had still not employed counsel. She said she was going to, but she has not appeared. Mr. King is present for the state. Defendant was, I received a email from the probation department, Mr. Arjima, that indicates that she failed to report since November 15th, which I think was the last day of her last pre-trial. They had a bed date for her at this counseling center. She called to reschedule the bed several times and has yet to enter treatment, and now has a warrant for failure to appear in the Hillsborough Municipal Court. So, court will order a capias for her arrest. The case will be put on the inactive docket. All right. Now, state. All right, case number 23, CR209, State of Ohio versus Terry Pigg. Are you Terry Pigg appearing there from the probation department?
Yes, sir.
All right, this is a Zoom pretrial. Mr. Pigg charged with aggravated possession of methamphetamine and possession of fentanyl-related compound. His attorney is Catherine Hapner, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. I believe this is a first pretrial. Final pretrial set for the 17th. Trial is set for February the 12th. Looks like the state provided discovery on December the 6th and a bill of particulars the next day. You've received both of those, Ms. Hapner?
Yes, I have.
All right, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Possibly. I need to discuss the matter with Ms. Barger, who I believe is the attorney for a co-defendant.
Oh, okay. All right, well, that'll be due by final pretrial if there is going to be any motion filed. And has there been a written plea offer provided?
There has, and I have discussed that with my client.
All right. All right, are there any other matters then to discuss?
No, Your Honor. No, Your Honor.
All right, thank you. All right, James. All right, are you LaDonna Adcox appearing there from the probation department? You'll need to unmute yourself. Should be down, there it is, okay. You're LaDonna Adcox?
Yes, sir.
All right, this is case number 23 CR208, the State of Ohio versus LaDonna Adcox. Ms. Adcox is appearing from the probation department. This is being conducted by Zoom. Her attorney is Sarah Barger. Appearing by Zoom and also appearing on behalf of the state is Prosecutor Attorney Collins. Defendant is charged with aggravated possession of methamphetamine and possession of fentanyl-related compound. This is a first pretrial. Final pretrial is set for January 17. Trial date is set for February 12. I see the state's provided discovery. And defendant did ask for a bill of particulars. And also I see now there's an motion for intervention. All right, and is the state in agreement with that motion?
Yes, we recommended it and provided the plea
All right.
form and stipulated questions to Ms. Barger.
All right, have you got the stipulated questions answered, Ms. Barber?
Not yet, Your Honor. I have a meeting with Ms. Adcox next Wednesday.
All right. All right, well, you go ahead and meet with her and sign that document, Ms. Adcox, and I'll go ahead and order the assessment. Have you been assessed yet for treatment?
Yes, sir, I have.
Where at?
It's, oh gosh. Right at the moment, I'm not for sure.
It's the recovery counselor, Your Honor.
All right, is she in treatment yet, or is just scheduled for?
She's in outpatient treatment.
All right, well, you go ahead and get in touch with your attorney, keep that appointment, sign that document. I'll order the assessment. We'll set a hearing for the motion for January 18th at 2 p.m.
Your Honor, I'm in a trial that day.
All right. What about the morning? Are you on all day?
I can do the morning.
We'll make it 9 a.m. on the 18th. All right. Then stay in touch with the probation department and your attorney, Ms. Adcox. Thank you. All right.
Yes,
Melanie
sir.
Jones, or I'm sorry, Melanie Anderson.
Is she doing this today, or are we doing it another day? Anderson.
She was fine doing it another day, but if we want to get it done today, it doesn't matter to me.
Who's that?
Melanie Anderson's a change of plea. She's fine doing it another day if we can get her in even
Well,
tomorrow.
I don't have it.
Next time.
Let's set it next week then.
Okay.
I don't have the calendar handy, but if you guys will get in touch with Miss Oyer tomorrow and get it set. All right.
Or you just do that, whatever works with your calendar. We make ourselves available, so.
All right.
That's fine. I'll get a hold of Marcia and then I'll text Janica and let you know.
Okay.
All right, just case number 23, CR 198, State of Ohio versus Melanie Ann Anderson. You're Melanie Ann Anderson appearing there from the probation department?
Yes, sir.
All right, Ms. Anderson is indicted along with several co-defendants. There's a multi-count indictment. It looks like she's charged in counts 27, 28, 29. This is a pretrial being conducted by Zoom. Her attorney is Sarah Barger, appearing from her office, appearing for the prosecutor's office, Prosecutor Collins. And prior to going on the record, Ms. Anderson coming in the room, attorneys indicated that there's been an agreement reached and a form signed, and you just need to schedule a hearing.
Correct.
Okay.
Yes, sir.
Ms. Barger, if you would contact Ms. Oyer in the morning, I'd like to get it set next week because the week after Christmas is going to be real busy. And looks like the 3rd and 4th is going to be pretty busy too. So, okay, so Ms. Anderson, stay in touch with your attorney. She's going to get a hold of the court assignment commissioner tomorrow. We'll have a hearing date sometime next week.
Okay,
All
thank
right,
you.
Thank you. Case number 23 CR 167, State of Ohio versus Ricky Allen Jones Jr. Are you Ricky Allen Jones Jr. appearing there from the probation department?
Yes, sir.
All right. This is a pretrial being conducted by Zoom. He is appearing from the probation department. His attorney is Sarah Barger. Appearing from her office. Appearing from the prosecutor's office is Prosecutor Collins. Defendant is charged with aggravated possession of methamphetamine and endangering children. Now, Ms. Collins, has a representative of the alleged victim and count 2 been notified of the time, place, and purpose of this hearing?
Yes, they have not wished to participate in any hearings.
All right. Now, Mr. Jones is set for trial on this matter, I believe, next month, January the 8th. I've received a plea of guilty form, Mr. Jones, that says you're going to plead guilty in this case. I'm going to hold it up to the screen. It has your name, case number, plea of guilty, and says to both counts. I'll hold it up to the screen. You recognize that form?
Yes, sir.
On page 3, there is a sentence about a third of the way down the page. It says, enter this plea voluntarily. It has what appears to be signature Ricky Jones, 12/6/23. I may be misreading that, but I don't know what all that says, but is that your signature?
Yes, sir.
And is that the date you signed it, 12/6/23?
Yes, sir.
And when you signed it, did you understand it was an agreement to plead guilty, meaning there won't be a trial? The next step in the case would be a sentencing hearing?
Yes, sir.
And did you go over this with your attorney before you signed it?
Yes.
Did she explain everything to you?
Yes.
And did you sign the agreement voluntarily?
Yes, sir.
Now, you signed it a week ago, and so you've had a week to reflect on it. Do you still want to go forward with this?
Yes, sir.
And you entered into the plea agreement voluntarily, and you're going to go forward with it voluntarily today?
Yes.
Right now, the agreement states that you're going to plead guilty to the charge in both counts of the indictment, count 1 being aggravated possession of methamphetamine under 2925.11 and endangering children under 2919.22A, both of the revised code. The first count is a felony in the 5th degree, and it says here you understand that carries a maximum prison term between 6 and 12 months, fine of $2,500. The endangering children charge carries a possible sentence of 180 days in jail and $1,000 fine. Do you understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction?
No.
Are you on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No.
Now, under the law, if you should ever be sentenced to prison for this offense, in count 1, count 2 is only a county sentence. Upon completion of that term, it is possible the adult parole authority to put you under post-release control for a period of up to 2 years, and if they did, you'd be supervised on the terms they set, and if during that period of time they determined that you had not complied, then they would file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control, sentence you to 6 to 12 months on count 1, and I'm adding to this form 180 days in count 2, and fine you $3,500. If you serve a prison term and you committed a new felony while under post-release or under community control, then the sentence in the new case could be ordered to be served consecutively to the sentence in this case for the violation. You understand that?
Yes, sir.
All right. Now, the charges in the indictment in count 1 alleges that on or about May 26, 2023, in this county, you did knowingly obtain, possess, or use Schedule II controlled substance, to wit, methamphetamine. Count 2 alleges on about the same date that you, being the parent, guardian, custodian, person having custody or control, or person in local apprentice of V, which stands for victim, a child under 18 years of age, to wit, 10 months, created a substantial risk to the health or safety of said V by violating a duty of care, protection, or support in violation of Section 2919.22A of the revised code. So those are the 2 charges that are in the indictment. Now, Mr. Jones, you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, Possible defenses you may try and raise at trial. Possible outcomes of a trial with your attorney.
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to get you to plead guilty?
No.
Now, on page 2, it indicates that you will enter a plea of guilty to the indictment, and it's state defense are recommending community control and a referral to drug court. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentence is up to the judge. So if you plead guilty, I'm not required to follow the recommendation, give you community control. I could decide you should be sentenced to a term of incarceration instead and fined. Do you understand that?
Yes.
Now, do you hold any kind of a license or certification from any state governmental agency that regulates any occupation or profession in this state?
No.
Right now, you have certain constitutional rights you must understand. Before I can accept your plea, first you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. The judge would then instruct the jury on the law. And that jury of 12 people would have to decide by unanimous verdict, meaning that all 12 would have to agree on a verdict on both charges before you could be convicted. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial. That means instead of a jury hearing the evidence, a judge will hear the evidence, the judge will apply the law, and the judge will decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them in open court through your attorney. What that means is witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney has a right to ask questions, which is called cross-examination, and the purpose of that would be to bring out evidence that might help your side of the case. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court, testify for you, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request, the court issues a court order. It's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes.
Under the Constitution, you have a right to confront the witnesses against you in an open court, and I'm sorry, I've already given you that. Under the Constitution, you have a privilege against self-incrimination. What that means is that you cannot be forced to give evidence in this matter or to testify at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, you have a presumption of innocence, which means you cannot, that you're presumed innocent until proven guilty by the state of Ohio on every essential element of each offense. So, the burden of proof is not on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the heaviest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally entered a plea of not guilty to the charges, Mr. Jones. That plea denied the allegation in each indictment, each count, and denied that you committed any crime and exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, that there are a crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or court trial. Waive or give up your right to confront witnesses against you and to cross-examine through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you feel you could have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal. That appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge of the possible sentences?
No.
You understand them?
Yes.
Do you have any questions about the plea of guilty, about the plea agreement?
No, Your Honor.
You understand it?
Yes.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes.
You have any questions?
Oh, no.
Okay, now, do you understand?
Yes.
All right. Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes, sir.
If any questions about the plea of guilty, what it means, and what will happen if you enter that plea?
No.
You understand that?
Yes.
Now, is there anything you need to talk to your attorney about before you can proceed? If you would like to, I can put the two of you in a breakout room. We'll just be the two of you talking. No one else will be able to see you or hear you.
No.
You, okay. I don't think we got this on the record, but Ms. Barger, you and your client are both in agreement. This plea can be conducted by Zoom rather than in-person appearance.
Yes, Your Honor.
And you're all right with that, Mr. Jones?
Yes.
All right. Then is it your decision to withdraw your not guilty plea, plead guilty to counts 1 and 2 pursuant to the terms
Yes.
of the agreement?
Yes, sir.
All right, then as to count 1, which alleges on or about May 26, 2023 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, charge of aggravated possession of methamphetamine, a 5th-degree felony with a possible penalty of 6 to 12 months imprisonment, a fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 2, which alleges on or about May 26, 2023 in Huntington County, Ohio, you did being the parent, guardian, custodian, person having custody, control, or person, local apprentice of V, a child under 18 years of age, to wit, 10 months, created a substantial risk to the health or safety of said V by violating a duty of care, protection, or support in violation of Section 2919.22A Ohio Revised Code, charge of endangering children, a 1st-degree misdemeanor, carrying a possible sentence of 180 days in jail and a $1,000 fine. How do you plead?
Guilty.
All right. The court finds on this day in open court, defendants advised as well as constitutional rights made no intelligent voluntary waiver of the same. Pursuant to Criminal 11, please accept the order filed. Defendants found guilty of the offense as charged in each count of the indictment. Court orders a pre-sentence report, which will include an assessment for substance use disorder, mental health issues for treatment there. Cases referred to the drug court, where his to consult with drug court coordinator. Sentencing will be set for January the 18th at 10 a.m. Now, anything, and bond will be continued. Anything further from counsel?
No, Your Honor.
All right,
No,
you
Your
see
Honor.
Mr. Arajima to make sure that you get your assessment done and you get your report done. All right.
All right.
All right. Thank you.
Good.
Well, I think it's finally up, right?